feel KFC.
Hey, blessed love to Zurich Spice House. Big up Bridge 99 FM, keeping the music playing every time. Yep.
Jamaicans, for justice, the people's champion. Justice for all, justice under the law, justice, Jamaica demand, right to life, right to liberty, justice for all, justice under the law, justice, the people demand, right to life.
Happy Tuesday and welcome to another episode of Let's Start Justice with the JFJ team. My name is Michael Jackson, Executive Director.
And I'm Jade Williams, Policy and Advocacy Specialist.
So there are several matters arising in the news cycle this week that we're going to be touching on. But before we get into that, one of them that we're going to be discussing in a more substantive way is the Clarke case. And the next court hearing is coming up on April 15th. Yes. So we're going to be talking about that with John Clarke, the board chair of Jamaicans for Justice and Attorney at Law, as well as Attorney at Law, Leonard Green, who is the attorney for the family. So we will have both men with us in short order. And the second half of the program, we're going to be joined by Miss Pamela Williams, who is the Secretary of the Coral Gardens Benevolent Society, to really get a sense of the status of the reparation following the massacre that had taken place and meted out against the Rastafarians several decades ago. Yeah?
Yeah.
All right. The week that was, there are several issues. I think we may have to beg a few more minutes at the end of the program to delve into some of them, because I really want to touch on the House Speaker conversation a little bit. But the week that was that I really want us to focus on is a very insightful and dare I say brilliant speech that was delivered by Miss Professor Errol Miller, who is former senator, former chair of the Electoral Commission of Jamaica, so very well versed on the issues. Mm-hmm. He was speaking at a Jamaica Teachers Conference, JTA conference held in Trelawney, I think last week or the week before, but very powerful speech. Yes. And the key component of that speech is that he had some comments regarding the decision of the Parliament to subsume the role of the political ombudsman into the Electoral Commission of Jamaica. Ill-advised, we called it from JFJ, and I think we need to reiterate our call for that particular legislation to be repealed. Mm-hmm. But let's hear from Professor Miller. So we'll take the first clip.
Just prior to the local government elections, Parliament passed an amendment to the Electoral Commission Interim Act of 2006 that subsumed the functions of the political ombudsman into the election commission and made every electoral commissioner ombudsman or ombudswoman. This is by far the worst legislation affecting electoral laws passed by the Jamaican Parliament since becoming a nation in 1962. It has no equal.
All right. Had I been in that audience, I perhaps would have been clapping as well, because that's a very insightful comment. Because for those who have had the opportunity to read the amendment, you will know that it doesn't clearly indicate how decisions will be taken based on the fact that you do have several commissioners. But Professor Miller went on to say some other things that is going to be heard in the next clip.
Adjudicating complaints of intemperate speech, silly public behavior, disputes about color, posters, paraphernalia, and graffiti in a period of heightened political partisan bravado and emotions in election campaigning, and without any sanctions to apply to deviance, is likely to diminish respect for both the Electoral Commission and its commissioners. In the past, the political ombudsman, while doing some good, was ignored by some candidates and their agents who defied their rulings, disregarded agreements reached, violated codes of conduct, all without consequence. To bring such impunity into the Electoral Commission is grossly unwise.
Grossly unwise. Just to quickly say something in a minute. The political ombudsman, all it needed was teeth. Yes. To get the work done. Prof said something else that I want us to focus on, that the political code of conduct had no sanction. And, Minister Chuck said that let's focus on moral suasion. Clearly, moral suasion has not worked for several members. When you look, for example, at the intemperament speech and utterances of Member Warmington, most recently, who still sits on the parliamentary committees overseeing Integrity Commission and so on. So, again, a repeal is necessary. And I think we note with concern whether or not the Electoral Commission of Jamaica can assume this function, given that you saw several areas of concern during the local government election. And to date, we have not heard a peep out of the Electoral Commission of Jamaica. So that is also another area of concern. But we thought it fitting to bring that particular speech to you. And I would urge you to listen to the rest of it because, again, Jade, I think you were also inspired by what you heard.
Yes, and I listened to the entire thing at the time, and it allowed me to finally hear in public, an opinion that we've been pushing here at JFJ, and to hear it so impassionately delivered as well was very gratifying. So I thank Professor Miller for that.
And you heard about the history of how education came to be.
It was a fascinating speech. Even a friend of mine who is not a Jamaican was listening to the speech at the time and was quite inspired herself.
Beautiful. and that's what you do when you're opinion shapers. So kudos to Professor Miller.
Indeed.
I will over to you.
All right, so I'm going to quickly talk about our Did You Know for today, and it is related to the matter that we're going to be examining, which is the Keith Clarke case. A major element of that case is something called a voir dire, and it is a kind of hearing that happens during a trial. So once your trial has begun, there can be questions of admissibility of evidence. In this case, it was whether or not the officers could be charged. And that matter, or any matter of evidence, can be decided on in what is called a voir dire, which is a trial that takes place within the trial that you are having. Now, once this evidence is presented in that trial and a ruling is made, then the matter is usually to move forward with whatever decision was made in the voir dire. So that's what that is. And we also have a trivia question for today, which asks, as is also related to our case, on what date was the West Kingston Commission of Inquiry appointed? Appointed is spelled incorrectly here, but it is spelled correctly on Instagram. For those of you who will be answering on Instagram, you can do so in our DMs, or you can send a message to 2397583.
All right, so let's get into it. So for those of us who have been following the news cycle and you're aware of history, we know of the situation in terms of the state of public emergency that was declared in 2010, where the security forces again were provided with extraordinary powers to try and secure Christopher Dudu's Coke. But on May 27, 2010, accountant Keith Clarke was killed in his home in Kirkland Heights in St. Andrew. And the three accused are Lance Corporate, Greg Tingling, and Odell Buckley, along with Private
Arnold
Henry. Thanks so much, Jade.
Yeah.
And it was alleged that the accused killed Mr. Clarke during the May 2010 hunt for Christopher Dudu's Coke, a period which also resulted in other fatal human rights abuses. 70 persons were killed, one of whom included a JDS soldier in Tivoli Gardens community of Kingston. And it was reported that Clarke was shot approximately 21 times in the incident because the soldiers allegedly, they stated that they were acting on intelligence. And they said that they heard that Mr. Clarke had Mr. Coke hiding out in his home with several armed men, but the widow of Mr. Clarke, Dr. Clarke, had indicated that no such thing happened. She was at home with her husband and their child.
Now, the matter has been in court since 2012, when the Director of Public Prosecutions, Ms. Paula Llewellyn, would have ruled that the accused men, the soldiers, were to be charged with murder. The trial was supposed to start in 2018, but was delayed due to certificates provided by the JDF attorneys that would have prevented, or should have the effect of preventing a prosecution from going forward. Now, these certificates were the subject of a case that concluded in front of the Constitutional Court in February of 2020. And the rulings by the judge we're going to hear from now.
In the circumstances of this case, the issuing of the good faith certificates was manifestly unfair and unreasonable, and therefore the good faith certificates are null, void, and invalid. 2. The defendants, this is the first 3 defendants, may not rely upon the good faith certificates at the trial of this matter.
And we'll hear further from the judge.
The court goes on to say it is hereby ordered as follows, that the criminal trial initiated by virtue of the voluntary bill of indictment originally issued in July 2012 by the Director of Public Prosecutions should be restored to the trial list and be permitted to continue. 2. That the good faith certificates or any certificate issued on the 22nd of February 2016 by the Minister of National Security outside of the emergency period were issued in circumstances that were manifestly unreasonable and unfair and are therefore null and void and without effect.
Now, following this, a voir dire was later mandated to assess the certificates and whether or not those certificates could be challenged. Now, on April 3rd, 2024, Justice Palmer would have handed down his ruling in relation to those certificates, stating that they can no longer bar the trial from going forward, and the DPP would have responded to that.
The judge did rule in favor of the Crown in that the good faith certificate would not be a bar to the Crown proceeding against the accused in a trial. The Crown has been ready for a few years, but, the matter went through judicial review, then to the Court of Appeal, and now, after this preliminary hearing has been completed, the court has ruled, and we did indicate that we are ready to proceed to trial.
The defense, led by King's Counsel Valerie Nita Robertson, did indicate their intention to appeal.
It would be an abuse of the process of the court, as the Court of Appeal has already pronounced on the matter, indicating that if it was that after the preliminary hearing the judge was to find in favor of the prosecution, then the matter was to continue on to trial, and the Crown is ready.
That was Director of Public Prosecutions, Paula Llewellyn.
Right, we have Mr. John Clarke, attorney at law and board chair of JFJ with us, but we're going to take the break and then we really get into it in terms of what exactly the issues are, this good faith certificate, whether that is something that we should be concerned about as citizens. Yes. But we take the break.
Property owners, let's get digital. Property taxes for 2024-25 are due April 1. Payments can be made by April 30 in full, half-yearly, or quarterly installments. Pay via these options. Online at jamaicatax.gov.jm, TAJ mobile app, mobile tax collection unit, NCB online banking, and Scotia online and mobile app. Call 888-TAX-HELP or visit www.jamaicatax.gov.jm for details. A message from Tax Administration Jamaica.
Tune in, log on and download the Bridge 99 FM app on your mobile from the Google Play Store or Apple App Store. That's the Bridge 99 FM, all one word, in the Google Play Store and Apple App Store. The Bridge 99 FM, Caribbean vibes amplified. Download it now.
Yo, dancehall can't start when the money must shut the content.
Right. Introducing the Bridge 99 FM Dancehall Chart Show.
I are the one and they are what?
All about our weekly top 10 music countdown, our Bridge Spotlight featuring artists and music producers, and our chat with the Bridge Jocks and music director.
We bring you in on the action. Just send your videos every week for your favorite artists on the chart in our Fan Affair segment. Do it WhatsApp 876-551-5782.
Jogger! It's new, it's authentic, it's trend-setting, and only on The Bridge 99 FM Dancehall Chart Show, hosted by Shell.
You know the vibes this Friday at 1 p.m. at the wickedest thing since dancehall. You know the thing go, we're bringing the vibes to the where, to the what, to the world.
Out of many, we are one Jamaica on the Bridge 99 FM.
The people's champion. Our mission is love. Our vision is love. Jamaicans by justice.
Welcome back to Let's Talk. We are discussing the Keith Clarke matter, and we are joined by attorney at law and chairman of JFJ's board, Mr. John Clarke. Can you hear us, John?
Yes, I'm here. Thank you for the invite.
Thank you so much, boss, for coming.
So we wanted to start off with a bit of context for those of us who were in high school at the time when this was happening. Could you give us an idea of what the major issues in this case were? The matter is from 2010. We are just now getting a solid court date in 2024. So what kind of issues would have led up to such a delay?
Well, unfortunately, it's typical of our justice system that, and perhaps even the process of justice, that invariably all views must contend. And in fact, I know one state organ that made the now famous PIP that mode makes the talk, essentially, that different views will contend. And in this matter, different views have contended and have gone to the Court of Appeal on multiple occasions as each side tried to do or get what they view justice to be. But what is important and what is unavoidable in this particular case is that materially somebody lost their life as a result of the actions of state organs. That's on the 27th of May 2010, which is almost more than 14 years ago. Somebody's life, as in Mr. Clarke, Keith Clarke, was killed. Now, ordinarily, when somebody is killed in a scenario involving police or soldiers or anybody at all, one would hope that that's 10.
Yes.
So 6 years later, yes.
Almost 6 years later. And it was also done by a different Minister of National Security. And so that would have caused some consternation as to whether or not he could have done it 6 years later. And the court would have examined that. One court, the full court came to one opinion, and another court came to a Court of Appeal, which is a superior court in terms of jurisdiction, overruled the full court decision and indicated essentially that, well, the good faith certificate can be issued, but what can be done in this particular case is a judge must make a determination as to how far this good faith certificate would go.
Yes.
And what we had in this particular court case was a judge examining the facts, hearing from both sides, and making a determination that the good faith certificate exists, yes, but in this particular case, it wasn't a bar to the prosecution, and that ultimately it seemed, bearing in mind what I've heard from media reports, that at the end of the day, at the appropriate stage, the relevant tribunal, whether it is tribunal of law or fact, would decide in the trial process itself what would be, if any, to attach to the good faith certificate, because the good faith certificate is being interpreted as not a complete bar to the prosecution, but essentially as a mechanism that one factor to be considered in relation to where justice lies in this case and whether or not it provides a complete answer to the circumstances under which Mr. Clarke lost his life. And ultimately, I want listeners to bear this in mind, that when we have state of public emergency, and we apparently are having some right now, what can happen is that you can lose your life, a family member can lose their life, and a minister of government can issue a good faith certificate to say essentially that nobody examine that circumstances because whatever took place against the backdrop, essentially, of state of public emergency. And for that reason, whatever actions were done in good faith in the exercise of the state organ's function as members of the security forces for public safety, the restoration of order, preservation of peace, and in the public interest. And now you must ask yourself the question, would you want that to be a complete license to ensure that nobody can examine how your family members died?
Thanks so much, Sir Clarke, because there are three things that jumped out at me as you were speaking and within the context of this particular matter. One, Mr. Clarke was killed in his home in Kirkland Heights. And I think sometimes as citizens of this country, we almost assume a kind of us versus them posture to say that, listen, everybody in this particular community is somehow some criminal element and therefore an interference with justice, where you can assume that authority to say, let me issue this certificate 6 years after, that almost excludes those who were involved from being prosecuted. You know, so that's the second thing that really jumped out. And then the third thing of concern is the pace at which justice is being administered here, because this is from 2010, it's now in 2024. And I think I would want to have your opinion. I know I said a lot of things, but just the general pace at which these matters are being brought before the criminal justice system, and, you know, any cause of concern within the bigger scheme of things from your perspective.
Well, it's a very difficult case, and what I believe, however, is not difficult to accept is that 14 years wait on justice is not particularly ideal, either for the officers who are before the court charged, or the family members who are waiting and hoping for justice. So 14 years is not ideal. But what one would appreciate, though, is that some of the issues raised in this matter are novel. So, for example, even the effect to put on the good faith certificate, that would have taken the Court of Appeal, for example, they would have heard the matter on the 10th of February 2021, and almost 2 years later, on the 30th of January 2023, we'd have a judgment being issued in this particular case. It's a very difficult decision, and a decision that involves and touch and concern many persons' lives. I ideally would wish that one day our judges may reach a stage where they would voluntarily come to a determination that judgments, even if you don't have a full written decision, should be issued in a timely manner, and ideally within a period, for example, of 3 months, unless there's certain extenuating circumstances that would say in this particular case it cannot be done for X reasons and Y reasons, but that deliberate efforts is made to try and deliver judgments in a timely manner. And to achieve that, for example, we may need, speaking about resources for judges, we may need to ensure that our judges get the effective assistance they need and the effective time that they need to write judgments in a timely manner. So we may need more judges, we may need more judicial assistance, but ultimately it cannot be in the interest of justice, nor good administration of the justice system that is taking 2 years to issue a judgment, bearing in line the fact that at least 3 Jamaican soldiers may have their entire life hanging on the issue of that judgment. And also for the family members who are waiting for justice, it cannot be ideal. They're going to wait 2 years, and that is concerning because there's a phrase that we often hear repeated, that justice delayed is justice denied. And in certain cases for these family members, some persons will start to wonder, after 14 years, can I really withstand cross-examination? Will I forget an important detail? And forgetting that detail will be turned into kind of the biggest lie. So ultimately, all actors in the justice system must be concerned about how long it takes for certain judgments to be issued. And hopefully, with Parliament looking at the justice system, looking at the needs, I also appreciate that our judges are getting a lot of work, and that essentially we are maintaining effectively almost the same physical structure that we had pre-independence, and that eventually much more will be done and needs to be done if we're going to keep up with the pace of the nature of the work that we're giving the court. But more persons are asserting their rights, more persons are going to court, but do our judges have the resources to do what they need to do? And that's something that needs to be examined.
And I think, Sir Clarke, just to add to a point you mentioned, when it comes to certain matters, we already know that the Constitutional Court moves at a much faster pace, and because of the the matters that are being heard. But when it comes to those involved in police killings by members of the security forces, you're talking about state accountability of people with extraordinary powers, awesome powers, the power imbalance, your fundamental rights to liberty and security. Shouldn't those matters somehow be expedited? How do we treat with it?
That is a question that is deserving of answer, but an expedited may mean different things because in this particular case, expedited matters, I believe, were expedited. But then if we are expedited, but the judgment is taking almost 2 years to write, then what does expedition really looks like?
Yes.
And ultimately, expedited can be expedited in one sense, but they're not expedited in terms of delivering the judgment. We have traditionally, and for very good reasons, resisted any attempt by Parliament or anyone to tell our judges how to run the court system. But in a scenario like that, we don't have speedy trial. We don't have timelines in relation to when judgments are going to be delivered, or at least public timelines. In a scenario like that, it makes it very difficult to know what really does expedition look like. And is a matter being expedited or is a matter just staying on the court's list?
Yes.
And that's a concern that unfortunately exists, and we have to find a way to resolve that.
Right. Thank you, Sir Clarke. Please stay with us for a few more minutes. We take the break, and I think Mr. Green will join us after the break as well.
Hungry for deals? Get the new Crunch Sandwich Combo from KFC for just $600. A finger-licking good deal. The time by KFC is
1:30.
Imagine your advertising dollar reaching your Caribbean and diaspora target beyond borders in a single rotation. It happens only on the bridge. Call now to advertise 876-669-5000.
Your taxes hold.
Property owners, let's get digital. Property taxes for 2024-25 are due April 1. Payments can be made by April 30 in full, half-yearly or quarterly installments. Pay using these options online at jamaicatax.gov.jm, the TAJ mobile app, the mobile tax collection unit, NCB online banking, and Scotia online and mobile app. Call 888-TAX-HELP. That's 888-429-4357 or visit jamaicatax.gov.jm for details.
KFC! New crunch sandwich from KFC. Great flavor, great price. It's for me. KFC signature, hot and spicy. Chicken with the lettuce, mayo, fries, and Pepsi. We've got you covered when you're hungry. The new crunch sandwich from KFC. We've got you covered when you're hungry. The new crunch sandwich from KFC.
Hungry for deals? Get the new Crunch Sandwich Combo from KFC. A small hot and spicy chicken sandwich with lettuce and mayo, plus fries and a Pepsi for just $600. Also available in barbecue. A finger-licking good deal. KFC.
No borders, no boundaries. Just the sound of good music.
The people's champion. Our mission is love. Our vision is love. Jamaicans.
Welcome back to Let's Talk Justice. We are revisiting the Keith Clarke case. We are joined by Mr. John Clarke, attorney at law, JFJ chair. Also, we are now joined by Mr. Leonard Green, attorney at law, who is representing the Clarke family. Mr. Green, are you hearing us?
Yes, I'm very much here.
Thank you so much for joining us. First thing I would like to ask you about, and you can share as comfortably as you may, is how the family who have been 14 years into this, trying to resolve this matter, doing, considering the most recent ruling received on April 3rd?
Well, it has not been easy for them because, as you said, 14 years is a long time. And there are a number of legal alleyways that the matter has had to travel. Mm-hmm. And it has been very challenging for them. But, I can say on their behalf that they are coping as well as they can.
Now, we have heard from the Director of Public Prosecutions that she is prepared to move forward on the court date that we received. I think it was April 15th. So how is the mindset of the family going into this newly decided date?
Well, they are pleased to an extent, but you know, the every day that they have to come to court, it is a difficult time for them. But they are happy that they seem to be coming to the end of what is clearly a very long road. But I think that they're in good stead, you know, and they're if one can imagine that on the occasion that they have to come to court and they have to relive the horrors of the incident that took place. This is difficult, but I think they are coping as well as they can.
You know, and thanks for sharing that with us. I think that some people who have been following it, and myself as well, are concerned that there might be further delay, considering the opinion of the King's Counsel who is defending that there's an intention to appeal. Is that even possible at this stage for the issue that we're discussing, or must the matter go forward now considering April 3rd decision?
Well, okay. The trial judge has indicated in no uncertain terms that we should not be discussing the content of the case publicly, you see, because there is a rule of law which says that when matters are before the court, they are deemed to be sub judice, and as such should not be liberally discussed by the parties. But what I can tell you is this, that a party who feels aggrieved is indeed entitled to file an appeal if they so wish. The question as to whether the appeal is one with merit, meaning there are good grounds on which to proceed with an appeal, is another matter. I imagine Queen's Counsel, Mrs. Valenita Robertson, may well feel that she has some reason to file an appeal. But the court, in fact, has ruled quite simply and straightforward that there's a prima facie case. Meaning, on the face of it, there's a case that the soldiers will have to answer to. And that is where we are now. My own view is that, you know, that's a proper ruling, and it is enough for the soldiers to prepare themselves for a trial date. And I'll tell you this, that it must be difficult for the soldiers as well to be going through this ordeal for 14 years. And I think it must be in the interest of all parties that at this time we come to a stage where the evidence is heard, the trial is done, the soldiers are given an opportunity to come and give their evidence and explain their defense, and a jury is left to decide on the outcome of the matter. It's about time. Time come.
I know we can't speak and we're coming up on time, but Mr. Green, what do you expect to happen on April 15, or what do you hope to happen on April 15?
My hope, and the family's hope, is that we will start a trial. Dr. Claudette Clarke will give her evidence. She will be cross-examined, and we will get over this hurdle of a criminal trial.
Yes.
The circumstances, in my view, warrants a trial, and the public will get a chance to hear what Dr. Clarke has to say. And we're looking forward to the commencement of a trial. Long overdue.
Yes.
And that is where we would want it to go.
Thank you so much, Mr. Green. Mr. Clarke, last word to you. As a human rights attorney, one of the most forthright, I think I have the liberty of saying.
Who do I have online with me?
Mr. John Clarke.
Oh, I didn't know that eminent counsel, Mr. John Clarke, is online.
That's what I'm saying. So I would like to have the last word to Mr. Clarke as we close out. Mr. Clarke?
Yes, there's a saying. I just wanted to make one point, though, as it relates to the appeal.
Yes.
Anybody can look at Section 13 of the Judicial Appellate Jurisdiction Act, And it specifically says the right of appeal on conviction in the Supreme Court in a criminal matter is triggered once there's a conviction. So I wonder, in light of that particular section, whether an appeal can properly be grounded pursuant to that act without the criminal matter being completed. That's one.
Yes.
But in any event, there's a saying, and it goes for all parties, that is both the accused and the family of the deceased, that justice delayed is justice denied. And one hope that after almost 14 years, that this matter will end, and that the nightmare, at least as it relates to this process, the criminal justice process, can be completed with a final determination, one way or the other.
All right.
And justice demands nothing less.
Thank you so much, gentlemen. We appreciate you always. Mr. John Clarke, Attorney at Law, Board Chair of JFJ, and Mr. Leonard Green, Attorney at Law, who is representing the Clarke family. Thank you so much, and we will be watching the proceedings closely. Mr. Green.
Thank you very much for having me online. Thank you to John Clarke and to all your listeners.
Have a good day.
Thank you, Mr. President. Nice hearing. Okay, bro.
All right, we switch the conversation now. We're going to be joined by Miss Pamela Williams, Miss Pamela Rowe Williams. I'm not sure if we have her online.
Yes.
Okay. Miss Williams, good afternoon.
Good afternoon.
Thank you so much for joining us. And I trust you are doing well. And
yes, I am. And thank you also for having me,
Yes, we appreciate it. For some of our listeners who may be too young to remember, if you could just walk us through briefly what exactly is the Coral Guard massacre, as some have termed the injustice that happened to the Rastafarian community. If you could just give us a quick overview so we can appreciate the conversation that we're about to have.
Okay, so there was a group of men, Rudolph Franklin being the leader of the group, who used to farm in the Coral Gardens area, adjacent to the Rose Hall estate. And each year, when his crop was about to be reaped, the overseer for the Coral Garden, for the Rose Hall estate, would call the police. Police would come on his farm, reap his crop, burn what they wanted to burn, take what they wanted to take, and tell him that he's a squatter and he should leave the property. Now, it is, as I said, it is adjacent to the Rose Hall estate. It was not really on the Rose Hall estate land proper. So this happened in successive years, and in 1961 thereabout, the police came to his farm. They did not find any ganja or anything. This is from an account by a policeman. The policeman gave details of what they found on the farm, and the fact that there was no ganja there in any shape, or whether be it growing or cured. However, the police a fracas developed, and the police shot him several times in his stomach and left him for dead.
Yes.
By the afternoon, when they realized that he was not dead, they took him up and took him to the hospital in Montego Bay. Now the doctor at that time, the sutures were not. If you sew up anyone, you would have to go back to the doctor to remove them. But in this case, his stomach was stuffed with plastic, and the doctor told him that whenever the plastic starts to rot, you will shortly die thereafter. So, and after the operation, he was taken to the court and charged for ganja and resisting arrest, and sentenced to time spent in prison. Now, while he was in prison, the stomach started to rot, and they discharged him. And so he came out. People who witnesses say that you could smell you could smell him from a distance, because of the rotting stomach. And he swore to take his own vengeance, because he as far as he was concerned, he had done nothing wrong, and he was imprisoned and left now just to die. so in 1963, he and some of his accomplices, about 5 of them, went into the area of the of Coral Gardens, and they burned down the gas station and raided. They went to an inn and they killed a salesman there. Then they went to fight in search of the overseer that used to call the police on him, and they killed him. And by that time, the police heard about the incident that was taking place. They put together quickly a group of policemen, and there was also citizens formed a militia and went into the Rose Hall in that area in the bushes in search of Rudolph and his accomplices.
Yes.
By the end of the day, without giving too much details of what occurred there, by the end of the day, Rudolph himself was shot and killed, and 2 of his accomplices, and 2 others ran away in the bushes, and also a total of 8 persons were killed, including policemen and a citizen. So, as a result of that incident, now the then Prime Minister Bustamante went into Montego Bay along with other leaders of the security forces, soldiers and policemen, and he declared that they should take in all bearded men.
Yes.
Our survivors say that he said that they heard him say that if the police station cannot hold them, then the cemetery at Bogue would be able to hold them. So
that is where we heard the infamous "dead or alive" statement.
Exactly. So after that, that was done. That was on the April 12th, the Good Friday of 1963. So that is why Rastafari really refer to that time as Bad Friday, because the entire country, wherever a Rastafari adherent was hiding or lived, they would be hunted even by their own families, cast with ropes, drawn into the police station. The jails were full. The Montego Bay jail was full, overflowing. There was just standing room only. Then some of them were taken to Lucy, where they filled up that area. They were taken to Trelawney. So the entire island, and some ran away, some were killed, and the entire island was just disrupted in this kind of way, where the Rastafari brethren were searched, were being sought,
yes,
and beaten brutally.
Yes.
So that is it is as a result of the Coral Gardens incident that this that the massacre or the atrocities took place, and that extended for weeks, even into months. And after that, the charges for ganja were strengthened to the extent where the judges were no longer allowed to use their own discretion, but mandatory prison sentences were put on ganja. And the entire Rastafari community, was discriminated against, and yes, they couldn't take their children to school. They were just completely marginalized.
Yes. Hold that thought for me, Miss Williams. We have to take the break. We're past due. But I hope the listeners are listening on to recognize when we talk about the injustice against the Rastafarian community. Right now, we utilize the community as some sort of tourism product for Jamaica, not recognizing, as we talk about mandatory minimum sentence and mandatory sentences, the implications of it over the years. But when we return, I want us to talk about this concept called transitional justice, when matters that were committed decades ago or for a particular period, how reparation, for example, and public apology, and those, efforts of saying that the state did wrong, how those things are progressing. So we take a break and then we return with Miss Williams of the Coral Gardens Benevolent Society.
Importers. Shipments requiring you to pay customs duties and taxes are cleared on a customs goods declaration known as an IM4 or IMS4. Ask your clearing agent to provide your customs declaration, customs assessment notice, and customs receipt once duties and taxes are paid. Where your clearing agent may not be able to provide the IM4 or IMS4, request your customs goods declaration registration number or C number, which can be used to verify your payments. Importers, request your IM4, IMS4, or C number. It is your right. For details, email the Jamaica Customs Agency at public.relations@jca.gov.jm. Jamaica Customs, keeping our customers in focus.
JampJA.org. Mind your business, JA with Jump Online. Are your business? They keep your government in line.
Use the MP tracker. If you watch how them a move, the account meter help them improve.
Take action.
Use the jump tool.
Track your MP cause they work for you. Mind your business, JA with Jump Online.
Let's monitor government at JampJA.org. Funded by the European Union and the UK International Development.
Hey, yo, yellow, you know it's Bounty Killer, checking out Bridge 99. Bridging the gap. The bridging will never stop.
The people's champion. Our mission is love. Our vision is love. Jamaicans, for justice. The people's champion.
Welcome back to Let's Start Justice. We are discussing the matter of the status of the reparation based on the Coral Garden incident. Some may call it, I call it massacre, one of the greatest injustices meted out to the Rastafarian community. And we are joined by Miss Pamela Rowe Williams. Miss Rowe? Mrs. Williams? Yes. Is it Mrs. Williams?
Yes, I'm here, yes.
All right. So I know you have, is it a 13-point plan from your group? If you could just walk us through that and the status of what the government had promised and what has since been delivered. Having heard from, I think, Dr. Horace Chang, Minister of National Security, about lands being turned over or will be turned over, another announcement that was made. And that follows an announcement made by Olivia Babsy-Grange, Minister of Culture, last year. But if you could just walk us through it for clarity.
Yes. In 2016, in 2015, the public defender produced a report which indicated that the Rastafari community was indeed targeted. Human rights abuses were done, and recommended, and gave some recommendations in that report. Now, in 2016, later on in 2016, the Rastafari Coral Gardens Benevolent Society hosted a community meeting, which really, because we wanted to get the input of the wider community in terms of the recommendations that were to be submitted to the government.
Yes.
And so at that community meeting, we came up with a 13-point list of recommendations.
Yes.
That one, the government should apologize, the state should apologize for the atrocities meted out in 1963. That there should be free health care for the survivors, and there should be cash compensation to the survivors and their families. Now, the status of that in 2017, the status of those recommendations. In 2017, we know that Prime Minister Andrew Holness gave an apology in Parliament.
Yes.
And in 2019, a trust fund was set up with the Administrator General's Department. The Ministry of Culture pays to submit funds into the trust fund from which the survivors are receiving monthly disbursements.
Because to be clear, they didn't get the funds in one go. It was monthly disbursements that were being made through this.
And they still are being made. Those who are still alive are receiving the monthly disbursements. However, the bulk of the recommendations, because it's a 13-point list, and I just spoke
And before you move on from that point, just for the listeners to appreciate, this trust fund was 2019. So what you would have found is that quite a bit of the survivors would have passed away. So they never really benefited.
Indeed. But for those who were alive at the time and are still alive, they are benefiting from the trust. Yes. And so that is why really, the community reparations that we have recommended That is why we have put so much emphasis on community reparations, because it is the Rastafari community. It is a community that was targeted for extinction, really. And those victims who are identified and their names were sent in to receive cash compensation, it's just a minority, as you just indicated. A lot, and the community is still suffering from those, the targeting, the discrimination, the marginalization still continues, even though the Rastafari image is being used as a tourism product.
Yes.
You know, so we still have that kind of discrimination that we are facing.
So the main things that remain outstanding, Ms. Williams, include what?
Yes. So we say that the government should assist the Rastafari community to develop a monument stroke museum in the Coral Gardens area. That's what we recommended. During the discussions with the Ministry, Jamaicans for Justice, that they have acted on our behalf with the government. And in the discussions, Minister Grange promised that while she would not be able to secure land in the Coral Gardens area, but the land that would be given to us, she would assist us to put up that monument. Now, the government, another recommendation was that a total of 300 acres, 100 acres of land in each county should be allocated to the Rastafari community for agricultural purposes.
Yes.
In response to that recommendation, Minister Grange announced in 2018 in Parliament that the 50 acres of land would be given to the Rastafari community for agricultural purposes. And the 2 lots of land in Albion, one would be used for a permanent elder care facility, and the other for an office for the Rastafari Coral Garden Benevolent Society.
And those are announcements. Have they been acted upon?
Exactly. Those were announcements in 2018, and here we are in 2024. Still not yet acted on. Another part of that announcement was that 3 scholarships, because we requested scholarships. We had requested that scholarships in respect of primary, secondary, and tertiary education be given to the Rastafari, children of Rastafari, annually. We recommended 3 scholarships in respect of each category. That is, so it would be. But however, in the announcement in 2018, Minister Grange announced that a total of 3 scholarships would be given. All right, and that is not yet acted on either. So, with Minister Chang's recent announcement in respect of the commitment given that by the end of June, the deeds for the 2 lots in Albion would be transferred and handed over to the Rastafari Coral Gardens Benevolent Society on behalf of the community. That it remains a promise. We are hoping that it is more than a promise now, and it is a serious commitment, and that will be fulfilled by the.
And I think the last thing I want to add on your behalf, Ms. Williams, in the interest of time, and you can add to this, I know you articulated on another interview the concern about the school grooming policy, that it's really just a principled guideline, if you will. There is not an absolute ban that schools can't act in a particular way, and if they do, they will be facing these particular consequences. So I do agree with you that the school grooming policy is almost a little bit lackluster and meek in its recommendations.
Even up to last week, we had to write a letter on behalf of a student at one of the high schools in Montego Bay, and we constantly get these requests from parents. Now, for those who do not know about us and are not able to refer their children to us, then you can imagine how many are out there that are being discriminated against in schools because there is not a written policy, and the school boards and the principals, they interpret whatever based upon their own societal, brainwashing that has gone on over the years against the Rastafari. They just come up with their own rules.
Yes.
So what we are saying is that the government should establish a written policy in respect of the wearing of locks in schools as well as at the workplace.
Yes, and adhere to the principle of the Constitution, freedom of religion, freedom of expression. Those things are important, yeah.
Exactly. You know, and in just as what you say, one of our recommendations for the community reparations is that tolerance of all faith-based communities should be ensured by the state. All faith-based communities, including Rastafari community, should be treated equally by the state.
Yes.
You know, so they I don't know how much more time I have to give you.
Well, we're up on time now, so I just will give you a minute to close out for us.
All right. So the other community reparations that we recommended that are still outstanding is that the state should assist the Rastafari community in documenting, preserving, and protecting and promoting its own authentic Rastafari history, knowledge, and culture. And right now we are intending that for the lands in Albion to be, the lots in Albion to be, one of them would be developed as a cultural center. And, you know, at our last the recent commemoration, we started a museum.
Yes.
And it is really time consuming. It costs a lot to reproduce materials. And we would really greatly appreciate the assistance of the state in terms of developing our own authentic Rastafari history and culture.
Yes.
The preservation of it.
Yes.
Yeah.
Thank you so much, Miss Pamela Rowe Williams. We appreciate it, and I have your number, so I will reach out to you on another matter that you raised.
Okay.
Thank you.
Okay. Thank you very much for having me.
Appreciate it. Mr. Kevin, am I permitted? Okay. Thank you so much. But Jade, I
wanted to quickly say...
No, just let me finish this topic before we switch to...
No, I wanted to speak about on this topic, yes.
Yeah.
Is that Miss Rose said some very poignant things. We are right up on the anniversary of this incident, this massacre, as you would say.
Yes.
And it brings to mind even... as you have mentioned, the school grooming policy and all of that. Unbeknownst to our audience, I was a lock-wearing child. And my whole family wore locks. My father was Rastafarian. And when I attended high school, I was instructed, and it was a fight that my mother had to go through with the administration.
And it's the strength of your mom for those who know her, yes?
Right, for me to not have to cut my hair. And it was a similar issue with my brother who came 3 years after me. So considering that we are still talking about this, it shocks me every day thinking that my mom had that win so many years ago, 2006, and we're still here in 2024 talking about something that's inherent to our culture. It's insane to me.
It is, and you know, and I'm happy you shared that personal experience, Jade, because it's one of those things I really want. I know we're strapped for so many competing priorities at JFJ, but each time, you know, you watch the news, and again, you experienced it.
Yeah.
I had Jerry curls.
Yeah.
But, you know, it's sad that we're still at that stage. And, you know, just to add to, thanks again for sharing, but just to add to this, we have too many announcements being made, and I think we need to get to the stage of holding our parliamentarians accountable. And even when Ms. Williams was talking about the land for agricultural purposes, it's not just to turn over lands, because we know that we're at this stage now. We have to talk about irrigation and, you know, the mechanics of ensuring that you can compete in a market. So it's not the lands, it's all the things that come with it.
Yes.
So you can actually compete well. So there's so many things. So but we will follow up with the community group and see. I know you have your trivia, but I wanted us to have, just as we beg the time, Rory's here as yet?
Yes, Rory's here, but he's good with us.
The House Speaker conversation, Jade, before you get to the trivia.
Yes.
You know, the Jamaica Gleaner asked us for comment a few days ago. For those who are following up, you know that the House Speaker had decided not to table 2 reports from the Auditor General. And you've heard our opinions that one constitutional authority cannot undermine the other. It certainly she doesn't have certain powers. And the House Speaker had given powers herself that is not permitted in law. So the Attorney General's report, or opinion rather, that would indicate whether or not whatever the opinion is, we
Whatever
don't know,
the
and I
opinion
don't want
is,
to
yes.
speculate how the law would permit the tabling or the handling of the Auditor General's report and the Integrity Commission's report. For those who remember, the former House Speaker decided not to share. The current House Speaker upheld that decision. The Jamaica Gleaner now submitted an Access to Information Act that is a constitutional right.
A request.
That's a
Through the act,
constitutional
yes.
right that is provided through the legislation, the Access to Information Act. The Solicitor General responded on the Attorney Chamber's behalf to say that the opinion will not be shared on the basis of attorney-client privilege. And the question we ask, who is the client?
Yes.
And whose privilege it is to assert? And let us be very clear. The Attorney General in the Constitution of Jamaica is there to provide legal advice to the government of Jamaica. And the government of Jamaica with a capital G in the Constitution is speaking to the cabinet. Yeah?
Yes.
It's not speaking to the government in the common G that speaks to all the state organs,
Yes.
which would consider the judiciary as well, and the executive branch and the legislative branch. It's just to the cabinet which sits in the executive branch of government. The House Speaker, as a member of Parliament, sits in the legislative branch of government. So therefore, the Attorney General is not the House Speaker's attorney within the context and concept of what the Constitution provides for, and certainly not her private attorney. So therefore, if it is not her attorney in that way, can privilege be asserted? That's something for us to ask ourselves.
Yes.
And even if one is to accept that the House Speaker could ask the Attorney General certain information, she would then be acting on behalf of the House of Representatives. And in that situation, for her to say I will table or not table would be dependent on what the House of Representatives has agreed to. And to my mind, and to the best of my knowledge, I stand corrected. I'm not sure that was ever debated. And therefore, a resolution was passed in the House to say, hey, table, ayes have it, the nays have it. That was never done.
Not in my knowledge either.
And that is problematic. So I want people to look on and say, how can you be a certain privilege when it's not your private lawyer?
Absolutely.
Public interest.
I have to
The
agree.
Attorney General's role outside of being the government's lawyer is the people's lawyer.
Yes.
You're an arbiter of public interest. And therefore, I think the Attorney General should be so empowered. And dare I say, when these public interest matters arise, the Attorney General's responsibility is to us, the people. Not to any ruling political party, notwithstanding how you may have been nominated to that post. I want us to think on these things as citizens. Yeah?
Yes.
It's a governance issue.
Absolutely. And I certainly hope the ATI requests will be followed up on, because I'm not certain as to the merits.
Well, I go a step further. The parliamentary opposition should understand its role. You're there for checks and balances. And when the ruling party acts outside of its bounds in law, in the Constitution, you have a mandate to take the matter to court and represent the people's interest, even when it is not popular.
Yes.
That is the role of the parliamentary opposition. So I hope with the amount of lawyers that they have on their side, notwithstanding there's 14 of them in the House, all it takes is one. And a private attorney can represent them in court on this particular matter. Take it to court and have it litigated. It's in the public interest to do so. Yeah?
Yes, absolutely.
That's my ranting for the day.
Okay, so I'll just quickly say, as Asaji, you won our trivia question for today. The answer was the 14th of February 2014.
What was the question
Sorry,
again?
the 21st of February 2014. The question was, when was the Commission of Inquiry for the West Kingston incursion appointed? And it was the 21st of February 2014. So, as
And the
Asaji,
report was heard years after.
yes, the report was seen, I think, in about 2016 or
And to date, not
2017.
one member of the security force.
Thank you, Miss Jackson.
But I won't rant on anything else. But it's
Okay.
something for us to pause and think about again.
Indeed.
Accountability.
Absolutely. Now, I believe we are at the...
Yes, because Rory needs to come on for his program. But thank you so much for joining us at JFJ Always. My name is Michael Jackson.
And I'm Jade Williams. We'll see you next week.
Bye-bye.
Jamaicans, by justice, the people's champion. Justice for all, justice under the law, justice, Jamaica demand, right to life, right to liberty. Out of many we are one in a Jamaica, make it a better place for the boys and girls, created equal by the creator, for equal rights and opportunities, no to unlawful detention, and police brutalization, class, gender, race or religion, we not tolerate discrimination.
To join the fight against injustice, contact us at 755-4524 or JamaicансForJustice.org.
The people's champion.
Yeah, man, this is Graham Smog, and whenever I'm rolling through Jamaica, got to keep my radio locked to the bridge, 99 FM, keep it locked. I also reggae and dancehall music, let's see.
Catch the KFC sponsored hour on the Bridge 99 FM every Friday at 7 a.m. to 8 a.m. in Up and Go to the World.